Good afternoon, everyone, and welcome to our latest Legal Cheek virtual student event in partnership with BPP University Law School. I'm Juliet Griffiths, Head of Student Engagement here at Legal Cheek, and I'm very excited to be introducing this afternoon's session, which is part of a series of SQE-themed events that we're running with BPP. Although, as you may well know, the SQE has now been in force for a few years, the assessments remain a very daunting prospect for aspiring solicitors. Just last month, we ran a taster session delving into the regime's first stage, SQE1. Today, we're going to be following up by covering the second stage of the SQE to give you a full taste of what SQE preparation is like. Besides this session, you can also find out even more information about the SQE on our SQE FAQs page, which includes answers to all your most frequently asked questions written by BPP's SQE experts. And my colleague will post a link to that page in the chat in just a moment. Moving on to this afternoon's event, I'm delighted to introduce BPP's Head of Outreach, Johnny Hurst, and Module Leader, Julie Manson, who will be hosting this workshop. Very shortly, I'm going to drop off stage and hand over to Johnny and Julie to dive into the taster session. But before I do so, I'll just quickly explain how this afternoon's event will work. For the next hour or so, we'll be hearing from Johnny and Julie about SQE2, the skills it covers, how you can hone these skills, and how you can give yourselves the best chance of passing the assessments. During this time, Johnny and Julie will give you a demonstration of an interview to assess, which should give you a glimpse into what it will be like to prepare for SQE2 yourselves. At around 5 p.m, we'll then move across to the Expo tab for an hour of virtual networking with the speakers, which is the perfect opportunity for you to ask all your burning questions. During the session here on stage, you can ask your questions as we go along in the chat tab, which is located on the right-hand side of your screen. However, we have got a very packed schedule this afternoon, so we'd really recommend reserving your questions for the networking, if at all possible. We're also going to be asking for lots of interaction this afternoon. So it's great to see so many of you in the chat networking at this stage, but once we get into the session, it'd be great if you could hold off just so that we can keep the comments focused on the taster session. Just make sure that when you do put a comment in that your chat is set to stage, not event, so that we can see your comments as they come through. Without any further ado, I'm going to hand straight over to Johnny and Julie. Thank you very much.
Well, thank you so much. Thank you so much, and welcome to our SQE2 taster session. I'm Johnny Hurst, as you heard earlier. I'm the head of outreach at BPP. Used to be a partner in a city law firm specialising in commercial property, and I'm joined here by my colleague Julie. Julie, introduce yourself, please.
Hi everybody, I'm Julie Manson. I'm coming to you live from our Waterloo office in a classroom here. I'm a corporate lawyer by background. I teach on our SQE programmes, other programmes as well, including in Waterloo as well as in Holborn, and looking forward to having this next couple of hours with you. Thanks, Johnny.
Thanks. And if you wonder what I'm doing with the green screen behind me, I run an independent YouTube channel called SQE TV. Check it out, folks. It answers all your questions on the SQE completely impartially, which you might want to check out. Anyway, apart from that, we're here today to talk about SQE2, and in fact, to give you a bit of a taster of what it's like to study for the actual course and how the assessment is actually going to run, although there are several different assessments. I think before we do anything, though, Julie, it's always a good idea just to put everything in context very briefly, because a lot of people are coming to the SQE journey. This might be their first exposure to anything to do with the SQE. So just in a nutshell, can you just summarize what the regime is all about, just with reference to this slide?
Sure. Yeah, thanks, Johnny. And there have been various regimes over the years, and Johnny and I are both old enough to remember various forms of qualification to be a solicitor. But the one that matters now is the SQE pathway. To be a solicitor practicing in England and Wales, you need to go through the SQE pathway to qualify. So you will need to have a degree or equivalent. So that might be a law degree or a different degree or the equivalent of a law degree. And then you would move on to do the SQE1 assessments and then the SQE2 assessments. And for those of you not familiar with that, SQE1 is looking at your legal and legal practice knowledge, which you might build up through your law degree or a conversion course or through self-study and then through going to law school. SQE1 is a series of multiple choice questions, challenging multiple choice questions across a broad range of areas, and you have to pass SQE1 to then be able to apply to do SQE2, which is what we're focusing on today. SQE2, we're going to explain a bit more as this session progresses, but that's looking at the skills needed to be a practicing solicitor. As well as the studying and the assessment side of things, you also need to have experience. It's called QWE, qualifying work experience. It's traditionally been called in the old days articles of association, and then more recently a training contract. Many firms still call it a training contract. But the difference now is with qualifying work experience, you might gain that experience before, during, or after studying for the SQE. You need 2 years equivalent. It could be with up to 4 different employers or different service providers. That combined with having a satisfactory character and suitability with the SRA is what together will enable you to then call yourself a qualified solicitor. So there's a pathway that you would need to go through to get to that position. Thanks,
Great
Johnny.
stuff. And so, just to briefly summarize, because we're going to focus on SQE2, but just to put this into context, SQE1, as Julie mentioned, is the multiple choice assessment. You get asked 360 questions that cover, first of all, these areas you can see in blue across the two papers. These are typical staple modules you'll find in any law degree, English law degree, or conversion course. And then there are all these practice based subjects, the black ones here, you can see here, and they're more or less equally spread across the two papers. And you need to pass each of those papers to be able to progress onto SQE2. As Judy said, they're quite intense, but we're not here to talk about SQE1. We're talking about SQE2. So we're going to assume that you've passed SQE1, or you might be one of the limited number of students who've got an exemption from SQE1 and can move on to SQE2. So Judy, tell us. We were going to talk about and maybe get the students just to suggest in the chat now what skills you think you need to be good at to be a solicitor, because of course these are the ones that are tested in SQE2, aren't they?
Absolutely. And we're going to talk about what skills are tested in a bit. Before we do that, we want you to be thinking, if I wanted to be a solicitor in any different type of law firm, practice area, working for government, working in-house, what skills would I need? So what skills do you think are needed to be a good solicitor for any type of legal practice? If you could put that into the chat, please, and under stage. And Johnny and I will be thinking about that as you're starting to put your ideas down.
Yeah, and of course there are a number of skills that really are, I think, are pervasive across the whole of legal practice, and there are some that are quite specific for particular roles. So,
Absolutely.
Stefania has come in there with analytical skill, communication, problem solving. You probably need that in most jobs, don't you?
Yeah, a lot of these are transferable, and a lot of them are things that you may have built up already in your current lives. So if you've worked, if you've studied, you've started building up a lot of these useful skills already, and things that you can continue to grow. So commercial awareness is a great one, knowing what's going on in the world and how that might impact you, your employer, its clients. Really, really important. Listening, we'll come back to that one later. Great one.
Yeah,
And
and I
negotiating.
like Archner's comment, emotional intelligence. They got a couple of people come up with that. That is really something that law firms are looking more for, to understand. Do you understand people as much
Yeah,
as you understand the law?
because AI can't do everything, Johnny.
No, it can do a lot, but it can't do that.
Can't do
Right.
empathy.
I think we've got some fantastic suggestions here coming up. Critical thinking, active listening. I think we're probably now able to show you exactly what SQE2 covers. So do you want to take us through the skills that are covered across SQE2? First of all, the oral skills.
Yeah, I will do. So, of course, when the SRA were changing the assessment regime into the SQE, they consulted on a wide variety of legal practitioners and clients to see what kind of skills are needed for solicitors in any type of practice. And they've divided that into two types, really, the oral skills and the written skills. So, any student that wants to go through SQE2 will need to be assessing all of these skills. So, on the first side, so the oral skills that you have up on the screen here, you've got client interviewing and advocacy. So being able to construct and lead a client through an interview, which we'll be focusing on a bit later, and having the skills to do that. That brings in a lot of the skills you've mentioned in the chat, like communication, attention to detail, empathy. And then advocacy, being able to present an argument in legal proceedings, being able to articulate things well, being able to focus on what's important there. And then on the right-hand side, we have the written skills. So we've got case and matter analysis. So some of you, again, talked about attention to detail, being analytical, that comes in there. Legal research, so having that ability to find the information that you need, finding it in a way that's going to be relevant to the client, using your legal knowledge and taking that into a problem-solving context. Legal writing, writing in a way that's going to be able to address the challenges and problem solving that you're doing in a particular context, whether that's writing to another lawyer or writing to a client or to somebody else. And then legal drafting, being able to draft legal documentation. And there are many different shapes and forms for that as well. And ultimately, Alexandra's just added ability to take feedback effectively. So actually building in that whole feedback regime into your understanding of these skills will be really important. But these are the skills that the SRA has highlighted are essential to any future solicitor in any type of legal practice area, and therefore you will be assessed in all of them, and you will need to reach a competency level that's the equivalent of being a day one solicitor in practice.
Brilliant. Thanks so much, Julie. Now, what we're going to do is to replicate a part of a workshop that we at BPP would give to students partway through their SQE2 preparation with us. And at the beginning of every workshop, we have a number of learning objectives that we hope that you'll fulfill by the end of the session. And for the one we're going to have a look at now, we're going to be focusing on these two particular learning objectives, 4 and 5. So understanding the statutory procedure to make a claim under this 1975 Act, the Inheritance Provision for Family Independence Act. And then we're going to carry out a case and matter analysis relating to a potential claim under that Act. Now, what we're going to do is to replicate the learning journey that you'll have as students as you're preparing for class, because of course you don't just rock up to class and expect to be taught everything. There's some method in the way that we've designed our course that we think really helps to produce the excellent results our students get, and it's this learning cycle. Do you just want to briefly explain how that works, Julie?
Sure. So if any of you are already at BPP, you may be familiar with this already. It's a learning cycle approach that we use across all of our programs. And it really is a brilliant way of really helping you get your knowledge, but also really embedding it and getting you confident in the knowledge and skills that you need to be successful. So it starts off with the prepare phase. So for any future workshop you're going to be attending at BPP, you will do preparation in advance of that. And there will be information available to you on our BPP intranet, which we call the hub, that will get you ready for that session. So included in the provision that we give you is everything that you need to read before. So your prepare stage will typically involve some reading from the equivalent of a workbook, and perhaps looking at some other resources as well, and getting that information that you need. We then move you into the apply phase. So before you come to the workshop again, you're going to be using the knowledge you've gained in the prepare phase and applying it to client situations. So that's how you start to really turn knowledge into something that a solicitor would do. So you would have perhaps a client case study where you're taking knowledge and you're giving advice to a client. Okay, so it's practicing in real life scenarios using the knowledge that you've gained in the prepare phase.
And what we're going to do now, of course, Julie, is to try and replicate a lot of that.
Real.
We're going to try and fast forward it, because what we want to do is to give you the opportunity to have some basic knowledge in some of the core areas of law that you can be assessed on in SQE2, and then put this in the context of how you're assessed in an interviewing situation. And for anybody who came to the previous session that we ran for SQE1, we're going to cover the same area of law, but of course we're then going to apply it now to an interviewing type situation rather than just multiple choice questions. So even if you weren't at the first session, don't worry, we're going to go over that area of law now very briefly and use a very similar case study to show it. So first of all, we'll have a bit of a crash course in wills. So that's one of the subjects that's tested in not just SQE1 but also SQE2. So we, of course, we know what a will is. It's a legally binding document that tells us how a person's property is dealt with after they die. A bit of jargon involved here. So what's the test data then, Julie?
Okay, so let's put it in the context of me, if I was doing my will, I would need to have written down somewhere what I want to happen after I die. So I would be the testator, or sometimes the testatrix is another expression you might see there. So the testator is the person who has written the will.
And then you need to appoint somebody in the will to deal with these things. What are these things, first of all, before we deal with who's appointed
Oh,
to
so
look after it?
these are my many belongings. So these are my millions in my bank account and my lovely big car and my huge house. So any assets that I have, this is known as my estate. Okay. So my estate, when I die, all of the belongings that are mine in their various shapes and forms, that would be my estate. Now, I need somebody to deal with that estate because I won't be around anymore. So I need somebody that I trust and respect lined up to look after my estate and to deal with selling things off and getting money in and then distributing it to various people. And that would be my executor or executors. I might have more than one. So that's the person that I've appointed to look after my estate after I die. And what is that executor going to do? Well, they will be responsible for fulfilling the wishes that I've set out in my will. And my main wish is what happens to any money once all of my assets have been sold, or even passing on my assets to other people. And the people I want to pass them on to would be my beneficiaries. So I guess perhaps my children, for example, in my case. So those are the people that are going to get my assets or the money from my assets after I've died.
So can you go to work straight away with administering the estate? Well, sometimes you can, but more often than not, you need this grant of probate. What's that then?
Yeah, so my executor, let's say I choose my husband to be my executor, can't just go to my bank account and withdraw all the money without evidence that they've been appointed as the executor. So they would need to apply for something called a grant of probate, and that gives them then the legal power to deal with my assets, to sell my assets or to transfer my assets.
Great stuff. So, armed with a bit of jargon, let's give you some details of a case study, just so that we're going to show you, just in outline, where this 1975 Act I mentioned earlier comes into play. I will explain what the relevance of this Act is in a moment, but we mentioned a claim being made under that Act. So, here's a case study. We've got Tara, who's married Robert, who's unfortunately died. Robert has a son, Andrew, from his first marriage, who's not Tara's son. So, what has Robert done in his will? How has he decided to distribute it? Well, first of all, let's see what's in his will. Well, he's got a half share in the home, the Tara owning the other half share. That's worth 300,000. Some personal possessions and savings, and he's got a few liabilities. But his net estate, in other words, his assets less his liabilities, come to around £500,000. So that is going to be potentially what Robert's estate consists of. And the relevance of this is now seeing it in the context of what he decides to leave in his will. And his will gives 20,000 to Andrew, £40,000 to the local cat shelter, and we call this case study family flaws, laws and pause. You can guffaw and respond accordingly if you wish to with as appropriate emojis. But this is a case where money's been given to the cat's home, a little bit to Andrew, the son, but most of it, the lion's share, is given to Tara. So, well, how do you think Andrew would feel about that? How do you think Andrew would feel about that, Julie? I'm sure you got an idea.
Well, if Andrew was a huge cat lover, he might be okay. But other than that, I think he'd be looking at those figures and thinking, hmm. So I don't know if Andrew's got any siblings. Let's presume he doesn't. So he is thinking, gosh, Tara's getting a lot of my father's estate and the cats are getting more than I am. I'm not
Great
too
pun from
chuffed.
Stefania there in the chat.
Yes,
Catastrophic for
lovely.
Andrew. Love it.
So this is the fun of the apply phase, isn't it? So we've got the prepare phase. We've talked about the law. Now we're going to apply it, of course, to this particular scenario. Um,
Exactly. Exactly. And we're going to give you a bit of law because it wouldn't be every case that Andrew could bring a successful claim. So we need to know, well, what's the basis upon which his claim could be made. So we need to look at the law relating to this 1975 Act. And we're just going to hone in on some of the bits and pieces. So the basic principle is that close relatives don't have any legal right to inherit from a relative. Basically, you're free to leave whatever you like in your will. But the court does have power to make provision for somebody who is an applicant, if they fall into the various classes of applicant who can bring a claim, if they feel that reasonable financial provision hasn't been made for them out of the deceased estate. So let's have a look at the class of people who can apply. Well, interestingly, the surviving spouse could do, but she looks like she's quite well applied, well covered there. So she could bring a claim for all of it, I suppose, but she could potentially bring a claim. But we want to see what the relevance is with Andrew. He's not somebody who has cohabited with the deceased, or he may have done, but not as a spouse or civil partner. But the one head where he might be able to bring a claim is he is a child of the deceased, and it's important to recognize it just doesn't mean a minor child, it could be an adult child as well. So he first of all could bring a claim because he's a child of the deceased, but it's not simple of just proving you're the blood, flesh and blood. You have to prove a little bit more than that. There's a bit more law to explain here. Do you just want to explain what this is there, Julie? Because I think they've heard enough of me for the moment.
Yeah, sure. I mean, there is a timing restriction. If you decide, if you're Andrew, you want to claim some more money from your father's estate, you have to do it within 6 months of the date of the grant of probate. So you could do it straight after your father dies, but you have to do it by the deadline of 6 months from the grant of probate. It does take a few months, I think, to get a grant of probate through, but even so, you're looking at 6 months plus about 4 months, I guess,
Yeah.
or up to a year. But you would have to respect that deadline if you want to bring that claim.
Exactly. And what's really interesting, particularly if you're a lawyer, is that there are different standards of financial provision that a court would order. If you're the surviving spouse, the amount of financial provision is much higher. It's more than just their basic maintenance. It's reasonable financial provision that a surviving husband or wife or civil partner would have expected to receive, not just for their maintenance. Whereas for everybody else, including, of course, Andrew here, it's limited to what they might receive by way of what would be reasonable for them to receive for maintenance. So things like their a roof over their head, food, that sort of thing, but not necessarily as much as a surviving spouse would expect. And this is where the court spends a lot of time, isn't it, Julie? If we just want to have a look at a few of these things, that when you're interviewing a client, you really need to be thinking about this. So when we do interview the client in a few minutes' time, have a note of this, screenshot it, or make some notes. Julie, a lot of these are quite relevant. What do we think are probably going to be quite relevant to Andrew's situation here?
Yeah, I think first of all, they are relevant. Of course, we can never be absolutely sure what the court would decide, but these are the kind of things they're going to be thinking of. So it says the court is required to have regard to, so to think about the applicant's financial resources and financial needs. So what is Andrew's position financially? Um, and also thinking about the financial resources and financial needs of any other applicants. So we don't know if any other applicants are going to be bringing a claim against this estate, if there are any siblings, for example, that have been left out of the will. And then very importantly at C, the financial resources and financial needs of any beneficiary of the estate. So we knew in this example that Tara has been left some money. Is that enough for the needs that she has? And the court would take that into account as well. Otherwise, we're also looking at the size of the estate. We'd need to have information on the value of the assets that are left over after all the expenses have been paid. And then also other needs of the applicant. So any physical or mental disabilities, for example, that the court should be taking into account. And then a typical kind of catch-all really at the end, anything else the court considers to be relevant in the circumstances. So these are
Always
things
a
that
good
the
bit of
applicant would
legislation that
raise.
way. You've got a
It's
catch-all
always
category at
helpful.
the end, just to give everybody a get out of jail free card if there's
Exactly.
a real reason. So that gives you a bit of background. Now we're not going to do an analysis because we haven't given you enough detail about Andrew's situation. But what we are going to do is in a moment going to go through a different case study where we're going to effectively replicate the type of scenario you could get in an exam. But before we do, just one final thing to mention: the court could also take into account where the applicant, as in Andrew's case, is a child of the deceased, whether or not he was expected to be educated or trained by the deceased and has lost out on that opportunity. So that would be a relevant factor for the court to take into account. So what we're now going to move on to do is really go on to the apply section and the collaborate section that we were doing in class, because in class, of course, Julie, you get the opportunity to interview a client on a case study to find out more about their particular claim, or if they're the claimant, or if they're the defendant in this case, what their position would be in terms of being able to defend the claim. So into the collaborate stage, just before we do that, I suppose it's probably just useful just to give people some structure as to how you would maybe analyze the position in writing, or perhaps if you were already giving the advice to Andrew. So there's a bit of a summary here. Do you just want to go through the basic structure of the basis upon which you would advise him that he potentially has a claim?
Yes. So when you get to the collaborate stage of the learning cycle, what we're talking about there is your interactive workshops, whether that's in person or if you're on a distance learning course, that would be online. But this is when you're very active and you'll be getting new information, dealing with that information in class, and then taking it forward into, for example, an interview scenario. So we provide frameworks to help you structure your thinking, structure your approach to your interview ultimately as well. So here it's a structure for going through all of the information that you've been given, to pull out the most relevant bits, because typically when you're dealing with clients, they're going to give you lots of information, not all of which will be relevant to what you need to be able to give advice. So here, looking at what the potential cause of action is, so that's what's the relevant law, and bringing out the relevant bits of the law that apply to the scenario that you're working with, and pulling out the relevant facts and matching those to the pieces of law that you're focusing on, so that then you can turn that into the advice that you need to be able to give, either Tara or Andrew, whoever it is that you're advising in this case. So if we go on to the next slide there, you can see the kind of notes that you might be making as part of your thinking and preparation before you go ahead into an interview scenario.
Great stuff. So it gives you a bit of a sneaky idea of how we might run an interview in terms of giving a bit of advice on the law once we've got all the facts from the client. But before we do that, let us now introduce the idea of this workshop, this taster session. Now, the assessment that this is based on is normally in three parts, isn't it, Julie? The students have some preparation time. They have a chance to then interview the client when they give some advice to the client. And then there's a separate piece afterwards where they will write an attendance note, or perhaps a letter of advice to the client summarizing the advice that they gave to the client. And which part of that are we going to be doing, or which parts of that are we going to be replicating today?
Yes. So if you look on the SRA website, actually, it will give you lots of information about how the assessments are formatted. Um, you would turn up with your legal knowledge intact from SQE1 and get some new information when you're there to do your assessment. We're talking about interviewing today. You would then prepare in your time slot for your interview, and we're going to be thinking about that interview today. This is where you're assessed on the skill of interviewing. Okay, the follow-up point to writing up the attendance note is where you're tested on your legal knowledge and the application of that legal knowledge to the scenario that you've just been interviewing on. So we're going to really focus on that middle bit. This is the bit particularly we find where students need lots of practice and lots of confidence building, and we really talk a lot in the sessions about the importance of good preparation and structure and how you approach that interview. So we would be spending time on that in our collaborate sessions during SQE2.
So in terms of the objectives, what we're going to try and do during the course of the next few minutes is to develop your understanding of how to approach that first part of the assessment, how to prepare to take on board all the information you're getting. We're going to give you some documents that are our friends at Legal Cheek are going to be putting on the chat in a few minutes' time for you to have a look at. But before they do that, the second objective is that we're going to evaluate what works and what doesn't work for the client's point of view, with a view to meeting that the assessment criteria when you're playing the role of a solicitor in the future. So let's ask you another question before we go into the case study itself and give you the papers. What do you think makes a good client interview? What are the key aspects to make sure, for example, if you're meeting a client who's either got a claim under this 1975 Act, or perhaps they might be the executor where they might have to defend the claim, what makes a good client interview? And you can see that the Legal Cheek team have put a link to the papers on the screen. Don't look at them yet because we're going to go through them in a moment, but just let's get a few ideas as to what makes a good client interview. I must have done hundreds during my time, Julie, and it's one of these things that you're not a born interviewer normally. It's a skill that you acquire, don't you, over a period of time.
Yeah, and of course, when you're doing your QWE, then you're hopefully getting a chance to observe people that are experienced constructing interviews as well and preparing for them. So what have we got? More listening and less talking. Note
Great point. That
taking, really important. Being adaptive. Roll with the punches rather than approaching with a set idea of how to proceed.
don't assume your client's going to present a particular fact pattern. I've seen that so many times in assessments where students are given a brief and they're expecting the story to go one way and they get completely sidelined by the fact that the fact pattern's completely different.
Yeah, and think so much about what they're going to say, they don't listen, which
Yeah,
is so
listening. Oh,
important.
great stuff, Aura. So don't interrupt, active listening, like nodding your head or echoing what they're saying. Brilliant. I mean, these are all fantastic things. Let's get a crack on with this because there's lots to get through. So what we want you to do now is to have the papers open in the link you can see that's pinned to the chat. But to help you, what Julie and I are going to do is to read through the documents that you would have for 10 minutes to read before you go into the interview with the client. So let's imagine you're preparing yourself for the interview. And the first document you get to read is this one here. Perhaps you want to read that out for us then, Julie? It's
Sure.
what is this?
So in this fictional scenario, you have received an email from a partner in the law firm. And the email says, "Hi," or "Hello. I've been contacted by Peter Latham." So Peter Latham is the client. "He has made an appointment to see you today following the death of his father, Richard Latham. Peter's the sole executor," we know what that means now, "appointed by Richard's will. We acted for Richard 10 years ago when he drafted his will. I checked our storage records and found the original will, and I attach a copy for your information. I also attach a letter that Peter has received from Harris & Co solicitors who are acting for his brother, David. Peter wants to discuss this letter from Harris & Co. In particular, he would like to know whether or not his brother, David, can bring a claim against his father's estate and whether litigation can be avoided. Thanks for your help."
Great. So lots to take aboard there. There's a couple of attachments. Don't worry about the footnote. There's often a steer given to students not to deal with particular areas, so you focus on what the examiners want you to talk about in the interview. And then we can see that the will is produced here. Now, you've probably not seen a will before, unless you've had the misfortune to be involved in a family situation. So it's the will of Richard Peter Latham, and it's dated 17th of April, 10 years ago. And it says, "I am Richard Peter Latham," and it gives his address. "This is my last will disposing of all my assets. Secondly, I revoke all previous wills and codicils." So, in other words, this is the only will that is relevant. Number two, I appoint my son Peter Richard Latham. Rather confusingly, the names are reversed there, but that sometimes happens in families. Of Peter's address to be the sole executor and trustee of my will. And then number three, for the administration of the estate, it says my trustee, that's Peter, will must hold my estate on trust. He may sell all or any of the assets in my estate as he considers appropriate from my estate. He must pay my debts, funeral, testamentary expenses, all the gifts in my will, and all inheritance tax due as a result of my death. And then it says my trustee must hold whatever remains when these payments have been made, defines it as the trust fund, on trust in the following clauses. The term trust fund also includes assets representing the remainder and any added income. And so this is the important bit. The absolute gift of the residuary estate. This is what the trust is going to leave. This is effectively the main gift under the will. It says my trustee must hold the trust fund on trust for Peter. Absolutely. So everything goes to Peter. And then it says, I declare that it's my intention that my son David Latham should not inherit from my estate. and then you've got all the execution clauses, which we don't spend any time looking at there. But in the exam, you'd probably just check it out just to check that it did comply with the requirements of a valid will, just in case that was an issue. But for our purposes today, that isn't. So looks like David might be a bit miffed there. So what? David's instructed solicitors, hasn't he, Julie?
He has. And David's solicitors have written to Peter, and you have a copy of that letter. So just to give you some of the key points then, I've been instructed by your brother David in relation to your father's estate. David's spoken to your mother since your father's death, and it is his understanding you are the executor of the will and that you will inherit all of your father's assets. David is upset and disappointed that he will not inherit anything from his father and has appointed us to advise. As one of your father's two sons, David intends to make a claim for half the net estate after tax and costs. We have advised him that this is the only fair course of action and that a court would uphold the claim. This is formal notice that he intends to make a claim under the 1975 Act on the grounds he has not been reasonably provided for by his father. David is keen to avoid involving the courts to save costs and time. We expect a response to this letter with proposals within 14 days to avoid a claim.
And he's advised to take legal advice. So obviously
Mm.
David's got lawyered up, and that would be something, folks, that you would have to spend 10 or so minutes reading through. We haven't taken 10 minutes to that, but what we would do, of course, before the meeting is once you've read the papers, what would you do before the meeting now that you've got an idea of what it's about, Julie? What would you spend the remaining time doing?
Well, luckily, I'll have brought my SQE1 knowledge with me, so I'll understand what the will's telling me. But I'd start to prepare for this interview, about thinking about what questions to ask, what I need more information about, and really just getting to grips with what the facts are here that I have in front of me. I would have also, before I even came to the test centre, thought about how I'm going to structure the interview. So I'll be getting
Yeah.
that at the front of mind and ready.
Think about how you'd start the interview, how you'd structured it, what
Exactly.
questions you'd ask, what you want to achieve by the what now you know the brief. What do you think you want to achieve by the end of the interview?
Me or
Yeah,
students?
or students. I'll maybe ask you just so we can keep going with the time.
Well, we haven't been told much really in the email from the partner about what our client wants to achieve and what he wants to do about this. So I'd be wanting to find out as much as possible about that. I want to find out what his feeling is about this. I don't know anything yet about his relationship with David or his mother or any other siblings, family members. There's lots of information that I need to get, and I need to do some questioning and a lot of listening.
There's a really good question here from Christian. Would you know specifically what topic is coming up before the assessment? You'll know you might know it's a wills assessment, but you won't know specifically what it's about, would you?
Absolutely, yeah. So that's the reason you do SQE1 first, and then you keep that knowledge fresh when you come into here because you don't know exactly what you're going to need. But you also will need to be having practiced the skills and ready for the skills, looking at what
Mhm.
the SRA is going to be looking for, which we'll get to in a little while.
So, folks, what Julie and I are going to do, and what you're going to do in a few minutes' time, but I want you to be taking notes whilst we're conducting the interview. Julie's going to play the part of the client, and I'm going to play the part of the trainee solicitor interviewing the client. And I'm going to give you, and want to make this very clear, a not very good example of how I would interview the client. And what I want you to do is to don't make comments in the chat now, but I want you to make some just private notes, because what we will do in a few minutes' time, once the interview is finished, is to pair you up in the collaboration area you can see on the left-hand side of the screen. You'll go into there in a few minutes to confer with each other, because this is part of what we do in class to see whether we're all on the right page and we've spotted stuff and can work out how we would resolve a particular problem and so on. But you're going to watch the interview now, and so make some notes. Don't put them in the chat, and then in a few minutes we'll pair you up to see whether you can agree some of the points as to where hopefully I could have made some improvements, and hopefully if we've got time we'll have a chance to see me have a better stab at the interview. So let's imagine we're in the assessment room, Julie, and effectively you're the client. So you are the assessor as well, and
Mm.
I am the student in the classroom or in the assessment room interviewing you. So let's imagine I've just sat down and I'll probably put my hand across and go, "Oh, nice to meet you, Richard." Oh, sorry, I mean Peter. Peter's. Oh, Peter's your name, isn't it? Richard's your father's name.
And Peter,
Apologies.
yes.
Oh, yeah, yeah. It's confusing, isn't it? Your name's the other way around in the will. Okay, so you've lost your father. Well, I lost mine a few years ago. You never really get over it. Anyway, so your brother solicitors, they're threatening to take you to court, aren't they? And I don't believe that your father's made any adequate provision for your brother in his will. I bet you want to defend that action, don't you? I would if I was in your position. What do you think?
Well, I'd really like to know a little bit more about the situation. Um, I I would like to think about what my options are.
Okay, okay. Well, I'm going to ask you a few questions then, and I'm going to give you some of the advice that I think you're probably looking for. Have you applied for a grant of probate yet, for example?
Sorry, I'm not sure I understood the question.
Oh, grant of probate, that's the permission for you as the executor. You're the person who has been appointed by the will to administer the estate, and that's your formal permission for you to be able to distribute the assets of the estate.
To be honest, all I've been thinking about is the funeral so far.
Okay,
No.
okay. Well, what's really at the heart of this is that we need to get to the bottom of why you think your father left you so much in the will and nothing to your brother. So, why do you think that was the case?
Well, I had a good relationship with my father, and the relationship between my father and my brother David wasn't so strong, and they've not really been close for many, many years. So I guess that's probably what's behind it.
Okay. Can you give me some particular reasons as to why they weren't so close?
Well, my father, he had a building business, and I guess he assumed both myself and David would go into the same business, and I did. David didn't. David was perhaps a bit more of a rebel growing up and liked to party and, yeah, got himself into some scrapes, bit of, drinking and drugs over the years. So I think my father lost a bit of patience with him when he was younger.
Okay, okay. And what about your and his financial position? Because that might be relevant when it comes to it from the court's perspective in deciding whether there is a claim, and if so, how much.
So you mean my brother?
Yeah.
Um, so I'm fine. I have my own business and it's successful. My brother has had quite a hard time, really. He has studied more recently, doing a course on electrical installations, and he now has a job. He doesn't earn very much, and he lives with his wife and children in a housing association property. But he does have a job. He does earn some money. He's a digger driver. His wife, unfortunately, is unable to work because she has health issues, and they have two teenage children that they're supporting.
Okay. So, well, I can tell you what I think the position is. He does have a reasonable chance of succeeding in a claim. It's under the Inheritance Provision for Family Independence Act 1975. He has a claim, so I presume you'd want to settle that without going to the expense of court proceedings then.
Absolutely, yes. Yes, I feel for my brother.
Okay, so how much would you like to offer him?
Well, I was hoping for some advice from you on that, really. Perhaps we
Okay, oh
could
yeah,
consider the value of the
yeah,
estate.
yeah. I was just thinking that maybe we ought to. Could you just set out what the value of the estate is?
Sure. So my father lived in rented accommodation. He didn't own any house or anything like that, but he did make quite a few investments in companies, including mine. He invested in my company and took a 20% share when I set up the company, and I've had the company valued. I think that share is probably worth about £100,000 now. And then he had savings and other financial investments, which we think are worth about 400,000. So the whole estate's worth about £500,000.
Okay, so how much of that do you think you'd want to offer?
To be honest with you, I would like to keep my company myself, so I wouldn't want to pass the shares on to David, and I'm not sure that he would be interested in that anyway. So I would be really happy to share the rest of the estate with him.
Okay, well, why don't we prepare a letter making an offer on that basis to them? I can get that out in draft within 7 days. Is that something you'd like me to do?
Sorry, a draft to.
A draft letter to his solicitors because I think they want a response.
Okay.
Um,
Would you mind if I just have a bit of a think about it? I have a really good relationship with my mother, as does David, and I
yeah.
just like to sort of run it past her.
Okay. Okay. Well, fine. Well, maybe I could just confirm my advice and then I can send that to you and then you come back to me.
Okay,
Okay.
that's fine. Thank you.
Thank you so much indeed for your time today.
Thank you.
There we go, right, folks. That's how not to do the interview. Now, what we're going to ask you to do is to hopefully armed with your notes and only spend 5 minutes, but go and think about the assessment criteria in terms of how you'll be assessed. You know, was there effective listening there? Was there um, good communication and explaining away that with language that the client could understand? Was I professional in the way I dealt with the client? Was I polite? Did I demonstrate client focus in my approach to how to advise the client? Um, and have a think about how I managed the interview as well, and what we want you to do, and think about whether I built up a trust and confidence with the client during the course of the interview. What we want you to do is to head to the breakout room, which is the one-to-one collaboration area, which you can see on the left-hand side of the screen. You'll be randomly put in pairs, and I want you to spend just 5 minutes listing between you, agreeing maybe the three of the worst bits of my performance, or if you wish, two really awful bits and one bit that wasn't too bad with my performance, because there were some things where I did save the day, but I don't think that would be a competent performance. Um, and then what we'll do is we'll bring you back here and you can copy and paste your um, ideas into the chat as soon as you come back in. So prepare some of your answers already so you can just post them into the chat in 5 minutes time. So just to be clear, what we want you to do now is to click that one-to-one collaboration area on the left-hand side of the screen. You'll be randomly prepared with another student and collaborate for 5 minutes or so to come up with three ways that you think I could have improved my performance, or perhaps two ways plus one way to improve it. Either will do. And come back in 5 minutes because that's part of the collaboration process. Off you go. So we'll see you back here at 16:52, 16:53, something like that. Okay. So just whilst we wait for people to move into that area, you go to the one-to-one collaboration area. You can see it on the left-hand side of the screen, and at 16:53 we'll bring you back into this main room. So hopefully everyone's managed to do that by now. For one or two of you who don't fancy that, and I think it's fair enough. Some students, I think, would feel a little bit nervous about doing this with somebody that they don't know, Julie. But I mean, we're very supportive in terms of people's learning journeys at BPP, which is why we're going to have a little chat about this now, because students might prefer just to pop some suggestions in the chat.
Yeah, I agree. I think it's something I said in the article before this session is about being brave about having a go. And if it doesn't go as well as you'd like, that's not a bad thing at all, because that's
Mm.
how we learn, and we learn and we remember um, different ways of doing things. So actually, Johnny, I'm not sure I would have assessed you as competent in that interview if I was assessing you.
Oh,
However, I would be giving you some very detailed feedback.
yes, and hopefully the students will be giving me some detailed feedback in a few minutes' time.
Yes.
Um, as Judy said, we hope that you've been brave enough to go into the room. But if it's not something you feel ready for at this moment in time, put a few comments in the chat. It'd be useful to see what you think I didn't do so well at, or maybe you found something that I did reasonably okay. But there were quite a few basic errors, I think, that I committed. So do put them into the chat. You should be automatically paired in the collaboration area, Archana. So once you go in there, if there's an odd number, it'll wait for the next person to come into the room. So go back in there, please, and try again. And the same for you, Phoebe. It should work. But if it's not working for you, by all means, let us know in the chat any particular ways that you think I could improve my performance. What's a common mistake that you often see students making, Julie?
I think people get nervous about going to something where they don't know exactly how it's going to go. So they prepare a script. Now, we can prepare quite detailed introductions and conclusions to an interview, but we don't know the client's situation. So the mistake that I've seen often in this example is explaining the legal position to the client without knowing what the client actually wants to achieve. Uh,
Mm-hmm.
So actually, someone said in the chat already, making assumptions.
Yeah, I'm sorry that people aren't being paired. I think if you head over there again, what happens is if there's an odd number of people, it waits for the next person. So do try and go there, just to have a brief chat. There's 2 or 3 minutes, but if you're happy just sitting on here and waiting for me and Julie to talk through the points, then happy to take your comments as well in the chat. Yeah, I think you're right there, Julie. It's something that students do get nervous about, and some students who I know are very strong students, they get quite nervous because they're put on the spot, and you can be as prepared as you like for written exams, but being put on the spot, it's a different vibe, different dynamic, isn't it, for an
Yeah,
oral assessment?
absolutely. And I've done quite a few what we call formative or mock assessments with students. And of course, the thing that you do as a tutor at the end of the practice interview is say, how do you think that went? And often students say, oh, I didn't ask enough questions, or I felt like I didn't talk enough and you did all the talking. And I say, well, that's great, because actually you needed me to do all of the talking as your client to get the information that you needed. So sometimes it's quite a shift in mindset to, you don't need to have everything rehearsed and have all of the answers up front. You have to interact. And that's the difference, of course, between SQE1 and 2. SQE1 is very much about using your knowledge to answer questions. SQE2 is about adapting to the situation that you're in.
Yeah, apologies for the
Integrating what,
the
yeah.
software not working there, folks. But I like Shakima's response here. Um, Not professional, talking to the client like a friend in the pub. I did start very casual, didn't I?
Yes. I just wasn't sure whether you prepared thoroughly, Johnny. And that
Well,
comes across, doesn't it, for the
it does.
client?
It
They
does.
want to feel special. They want to feel that they're getting their money's worth from their time with their solicitor. But they also want to feel like they're the only person that matters in that 30 minutes or whatever the time is that they're going to get with that solicitor.
Good question from Phoebe. Is the client interview always on wheels in the States, or can this change? What's the answers to that then, Julie?
Oh, well, one of them will be, won't it, Johnny?
Yeah, but you'll do more than one interview
Mm.
assessment. Absolutely right. So you've got, well, we're now at 16:53, so hopefully people are coming back into the room now. As you come back into the room, folks, do now copy and paste some of the things onto the screen. So options there, 3 awful things, legalese was used. Yeah, share your comments, folks, on the screen. Client was not the main focus. There was no golden minute to give the client a chance to explain their situation or their expectations. Really good point, that wasn't it? Great stuff. What about Waleed's contribution there, Julie?
Mm. Try listening, Johnny, to the client,
Yeah.
and then providing a tailored to the client and easy to understand response. So it's getting the balance right, isn't it? I'm a person that understands some things, but I didn't know what you meant by grant of probate, but I
Mhm.
know that I'm the executor. So trying to get the balance right with speaking in a way that the client understands, not being patronizing or too casual, being professional, but then also not being too distant and using understandable jargon.
Yeah. So any other comments?
Lack of
Astrid said, I think one
grasp.
of the main things that I noted was a lack of grasp of the financial position of the brothers. Yeah, it took me a while to establish that, didn't it? And I'm
Mm.
not sure I really focused too much on that.
And not knowing the name of the client, goodness me, I mean, I
Yeah.
think that's a really bad start, isn't it? It's not gonna
Are
put the
you
client into good
Bruce?
frame of
So
mind.
talking over you was one thing, and I've just done that.
We're
But
in the relaxed stage now, aren't we? So we're okay. We're okay.
but I think not knowing the client name, getting that wrong. Do you know, we see that in law firm applications for training contracts, and we see it in oral assessments when people get the parties mixed up. You need to be really secure on your fact pattern. And for me, confusing the names of very similarly named people lost me rapport from the first second I was in there.
Yes. Yeah. And there's so many good comments here, lack of empathy, too much legal jargon, too much that I didn't understand. And then also it says, did try to provide a legal solution, even though his solution probably doesn't align with the client. Align with the client, such a good way of putting it.
Mm.
Yeah. I don't feel like as a client, perhaps I even had enough opportunity to get the information across that I have. Um, even if the interviewer was unprepared, they could have carried themselves professionally. Yeah, absolutely. Saying you can never get over it. It's not about you, it's about me, isn't it? It's me, the
Exactly,
client.
exactly. I think we sometimes overshare. I mean, that conversation in a pub comment that somebody made earlier, it isn't a conversation in a pub. It's not about empathy in that sense. Yes, we want empathy, but they don't want to know about me. They want to know
No.
about the client.
We need, I mean, if you go back to the assessment criteria, and look at what the assessors are looking for, which is what a client would be looking for as well. That building of trust and confidence. If you get things wrong at the beginning or you don't set the right tone at the beginning, is the client going to have trust and confidence in you as their legal advisor? If you're not prepared, if you get the names wrong, if you don't
Yeah,
quite set things up, I don't really know what's going to happen in this interview. I wasn't quite sure what was going to happen at the end. Then that isn't so good for the idea of having an effective relationship as well.
yeah. Norika says too much legal jargon. Melissa says
Not coming back.
they're not coming back. I didn't
I'm not
build.
paying your bill.
Exactly. And we've got to remember clients are your best. If you do a good job for a client, it's the best way to market your firm. Because if you do a good job for client A, they'll recommend you to client B, and that's how you develop your practice. So
Yes.
it's about creating that relationship from moment one. Well, lots of great comments here. Should we give it another go, Julie? Should we see whether I can? Now, I'm not going to do a perfect interview because I still want people to see whether they can see the mud through the hopefully the better
Yeah.
examples.
But
But
it doesn't have to be perfect, does it? You've got to be good enough. That's the thing, isn't it? And sometimes things don't quite go to plan. Small errors might happen, like the minors that you might have in a driving test. So things may not be perfect on the day of SQE2, but what you're aiming for is to be the absolute best you can be to get to that threshold of being a what they call a just competent day one solicitor, an inexperienced but competent day one as solicitor. So
okay,
let's see if you
so
can do that, Johnny.
I'm hoping I can do. Here's hoping anyway. Right, I'm just going to get my preparation because I've prepared for this because I am a prepared student this time.
Yes, good.
Right, okay, so let's imagine we've sat down for the interview. Julie again is playing the part of the assessor, the client, and I'm playing the solicitor. Well, nice to meet you, Peter. I'm Johnny Hurst. I'm an assistant solicitor here at Price Prior Solicitors. I'm so sorry that we're meeting you under these circumstances.
Thank you.
How are you doing?
I'm not too bad, thank you, and thank you for saying that. Yes, just got to get on with things now.
Yeah, I'm sure. I'm sure. Just some basic things before we start, if that's okay. I've got your full details. Obviously, we've got your will. Are you still at 12 Blickling House, the address that's on the letter from your brother's solicitors?
That's right. Yes,
Okay. And just for the record, can I confirm your occupation?
I'm a builder, and I've got my own business.
Oh, fantastic. Okay, well, I might explore that a little bit later on,
Sure.
if I can do. But from my understanding, and let me see if I'm right, but correct me. I think you're here to discuss the contents of your brother's solicitor's letter. Um, as you know, they're threatening to take legal action against you because they don't believe your father made adequate provision in your brother's will. Is that why you're here today to seek that advice?
Yes, I'd like to know what the letter means really, and think about what the options are. I certainly don't want to be going to court or anything like that, but I just wanted to know what is the legal position here, and is there anything that I need to do?
Okay, that's fantastic. So what I'm going to do is to ask you a few questions in order for me to complete the picture, because there's quite a lot of missing facts that I'm going to need to fill in order to understand the whole background to the situation, and then I'll be in a position to give you the advice on what you come here today, and maybe some options going forward, and maybe we'll have a few things to do, some actions as a result of this particular meeting. How does that
Sounds good.
sound?
That sounds fine. Thank you. I've got some information with me, so I've got some notes I can use if they're going
Oh,
to be useful.
that's really helpful. So could you just outline for me, obviously we've got you, we've got David. Can you just give me details of all the members of the family?
Sure. I mean, in terms of siblings, it's just me and David. So I'm the older brother. He's 2 years younger than me. So I'm 52. He's 50. And then mum and dad. But mum and dad divorced many years ago, 30 years ago, I think it is now. They remained on talking terms, but they haven't lived together for a very long time. So dad lived on his own. Mum's remarried. And that's
And,
everybody.
and your father, did he have a surviving spouse or partner?
No, he was on his own.
Okay, that's really helpful. That does simplify things from our point of view. Um, could you outline for me what your father's estate consists of? Because that's important.
Yeah, I mean, these are just kind of rough figures at the moment, but just to let you know, he didn't own a property, so he rented, so no house or anything like that, or car, and nothing like that. He didn't really have many assets, but he had invested in my company, so he has a 20% share in my building company, which I've estimated is worth about £100,000. And then he has other assets, mostly savings in accounts or investment funds, and altogether that comes to about 400,000. So total around 500,000.
So £400,000 being the main assets of the estate, plus the
Yes,
shares in your company, which
that's
you
correct.
mentioned at the beginning. I think you said it was a building company, didn't you?
That's right. Yes.
Yeah. Okay. And obviously the will might have come as a surprise to your brother. Has it come as a surprise to you? What's the background to the reason why your father decided just to leave everything to you?
Yeah, I mean, I was always very close to dad, so I knew all about this. I mean, dad and David never had a particularly great relationship, whereas dad and I have always had a really good relationship, particularly as I went into the same business as him. But when dad did his will, it's about 10 years ago now, he did tell me at that stage he wasn't planning to leave anything to David. And I did try to change his mind because I didn't feel that that was right. I mean, they may have had an up and down relationship, but it's still his son. But no, he was fixed. He was quite stubborn, to be honest. We didn't really discuss it much after that, to be honest with you. And I'm not surprised that it remained as it is.
Okay. And in terms of your financial position and David's financial position, obviously you've got a company. How are you doing compared to David? What's your relative financial positions?
I mean, I know everything through mum because both David and I are close to mum. I see David occasionally. We're not close, but we are in touch. I'm pretty comfortable. My business is pretty successful, generates me a good income. David, from what I understand, is now working, but he has had long periods of unemployment. He has struggled a bit. Had a few problems with drink and drugs really when he was sort of teens and 20s, and he has settled now. He has done a course in electrical installations, which I hope will lead to something. He's living in a housing association property with his wife, and he has two teenage children. He is the only one that works in that household. His wife is has health issues that means she can't work. So he does earn some money. He's a digger driver at the moment, so it's not a big income. I don't think there's a lot of spare money around, to be honest.
Yeah, and the course you mentioned he did. How did he manage to finance that if he was not doing so well?
Well, actually, I think my mum negotiated this, but my dad actually contributed to that. Although they didn't directly communicate about it, he did make a contribution by paying the fees to the college for that course. I think he was just really keen for David to do something to give him options in the future.
Okay, well, that's really helpful. If anything else occurs to me, I may ask you another question after this interview. But let me tell you where you stand. Because David is your father's child and no provision has been made for him in your father's will, he does have a potential claim against you that reasonable financial provision hasn't been made for what we call his maintenance. It means his keep, his food and drink, that sort of thing. And what's really significant here is that your father, you mentioned, was supporting him a little bit in terms of the education, but also your relative financial positions. You seem to be doing a lot better than David. He seems to be struggling, and that would be relevant in any decision that a court would make. And given the size of your father's estate, 400,000, as you say, plus the shares in your company, I think there's probably scope for a court to make an award, particularly as you're significantly financially better off than David. It's really difficult to predict with any certainty what order the court would make, but I think they would make an order. And therefore, my advice would be that if possible, we were to try and work out a way to try and settle this claim sooner rather than later, because it would be the least expensive way, most likely, to get it resolved. Does that make sense before I give you sort of the pros and cons of each option?
It completely makes sense. It's really good to hear that. Actually, it's really reassuring because it makes me understand or think about my dilemma. Because, of course, I want to respect my father's wishes, but
Mhm.
equally, David's my brother, and I want to help him. And I genuinely do want to share the estate with him. I just want to make sure that we're doing that in the most appropriate way.
Yeah, and one of the reasons for trying to settle this, as well as saving you costs and time and stress, is that you could be penalised in costs if you were to go to court and were to contest the claim, but also
Mm,
the aggravation, the stress, the family breakdown as a consequence. It sounds like there is still a relationship there with David.
yeah.
There is a strong risk that it gets destroyed if you were to go to court, when it does sound like you're probably in a position to try and make him some sort of offer. Now, it may be too soon for you today to think about how you would want to pursue that, but that would be my recommendation rather than going to court. Um, we can go about this in two ways. We could talk about now how you would potentially want to make an approach to his solicitors. Remember, we've only got 14 days to do so, according to their letter.
Mm.
Or you could go and have a think about it. Maybe we could have a chat on the phone in a few days. How would you like to pursue it?
What I'd like to do is take away the knowledge you've given me now and have a chat with my mum about it, and then think about whether I respond directly to David or through you and his lawyer. I'd really like to keep control of my own company, but other than that, once we've paid for the funeral and all other expenses, I am really willing to split the estate between us.
Okay, well, maybe we can talk specifically how we would make our approach. What we would want to do is to give ourselves a little bit of leeway, negotiating
Mm,
room from the first offer that we make, but we don't need to decide that now. So, in terms of next
okay.
steps, I will send you a letter confirming my advice. I'll send it by email within the next 24 hours. And then if you go away and have a chat with your mum and maybe come back to me, maybe we'll have a chat on the phone to agree what potential offer you wish to make, if that's indeed your conclusion. How does that sound?
Yeah, that sounds fine. So today's Tuesday, so it'd be great if we can just kind of have a plan by the end of the week. So I'll go and have that conversation and get back to you.
Perfect. Let's do that then. Thanks so much for coming today.
Thank you so much for your help.
There we go. We slightly overran on that, but hopefully it gives you an idea, and a lot more love for the interviewer, I think, this time round, Julie. I can
Yeah,
see.
I feel really good because you've actually really helped me understand what the position is and feel confident now in my next steps.
Yeah, and some really good feedback here. Paulina said explaining legal concepts in accessible plain language. That's the key, isn't it? And not using that legal jargon. Any other comments jump out?
Yeah, I mean, I saw some popping up earlier. I was trying to read as we were talking, but things around having a much better structure, it's much clearer, the flow of the interview,
Hmm.
but also that empathy at the beginning as well, offering your your condolences or and recognizing that it's a difficult situation for me, and responding to what I was saying and listening to what I was saying as well, and getting that feel for what I wanted to achieve here. And
Okay.
very good, yeah.
Okay. Well, Azad's mentioned some comments. Interviewer didn't ask the client if there was anything else missing before he gives the initial advice. Yeah, perhaps I could have asked that. Was there
Hmm.
anything else? Yep. I was. in fairness, Azad, I was probably trying to bring the interview to an end because we've run over 5 o'clock, our sort of end for the first session, but that's fair enough.
Should we be taking notes when the client's responding to questions? I think that would be sensible, and it's something that you can practice doing as well. It's that balance between eye contact and listening and keeping enough notes that you don't forget things as well.
Yeah, Greg says, "Can I do the SQE2 interview for him?" Oh,
That's a no, I'm
that's very
afraid.
kind of you, Greg. But I think when you see it modelled this way, hopefully it will give you confidence about how to do it next time, or the first time for you. Well, listen, folks, it's been really great just to share that with you, and thank you for your feedback. And hopefully, you've learned quite a bit. These slides, which we'll share a PDF of after the session, and just gives you some bullet points. I think what was really important about that first interview, wasn't it, that I didn't probably know my law well enough. I wasn't really prepared, and that was something that really shone through and was probably one of the main reasons why I failed. Anything in this bullet point list that I did quite well, particularly, you think, in the second interview?
I thought that you had a really good tone to the way you were speaking, and when I look at the assessment criteria, you came across very professional, and that includes the fact that you were organised and prepared for the interview, that you'd thought about the structure of it in advance. And then also thinking about building that effective relationship, making sure I was happy and I had understood things. You didn't patronise me, you didn't overuse any legal jargon either. So I think you got that really nice balance there, which was important. Somebody put something in earlier about whether you're tested on your legal knowledge as well, I think it was. Now, your legal knowledge would be tested in the follow-up to this part of the assessment. So we focused on the preparation and the actual interview. You would then go away and write an attendance note, and that would be to summarise the advice that you'd given to the client, and you would be assessed on your legal knowledge in that aspect.
Interestingly, you're not normally assessed in the interview by a lawyer. It's normally a lay member of the public, very often an actor who plays the role of the client, who is trained to assess you on your interview skills. So they are given very detailed training by the SRA to spot whether you've got good structure and so on. They don't need to be checking you on the law because, of course, that's what's assessed, as Judy says, in the follow-up in the attendance note. So that's how that's assessed. Well, because we've run over, I think what we'll probably do, we're very happy to spill over further discussion of this if you wish to do so. But as we always do at the end of an activity and a session, Julie, we always go over the learning objectives again, don't we? What's the purpose in that from a pedagogical teaching point of view?
Yeah, so the learning objectives we go through at the beginning to show students what we'd like to achieve in that session, including the prepare, apply, collaborate, and consolidate phases, and then to then look back and reflect and look at the journey that you've had throughout your learning to check whether you've achieved those learning outcomes. It's an opportunity to revisit them, to self-reflect, to clear up any areas that you're not sure of as well. So it rounds off the session really nicely there.
Great stuff. So I can see some good questions. Keep those in the chat or copy and paste them because we're going to remove location now. I particularly like Alexandra's question. Let's save that for the networking now, which we're going to move into the expo area on the left-hand side of the screen. Julia, you're coming in now. Juliet, sorry, beg your pardon. Juliet's coming in now just to give you a few words.
Brilliant. Thank you so much, both. That was an absolutely fantastic introduction to SQE2, and I can see that many students have commented that in the chat as well. So yeah, thank you so much. As Johnny mentioned, this is not the end of today's session. We've got roughly 45 minutes left where you can ask all of your follow-up questions to Johnny and Julie in the Expo tab. But before I wrap up, I just wanted to remind you that if you want to find out more about the SQE in your own time, please do check out our SQE FAQs page. We've got dozens and dozens of questions up there with answers written by BPP's SQE experts, covering a massive range of different topics. So please do check that out if you want more information. But for now, we are going to be heading over to the networking. So for those in the audience, if you just head over to the Expo tab on your left-hand sidebar, Johnny and Julie will be heading over there in just a moment, and you can ask all your questions, not even just about SQE2. If you have questions about SQE1, SQE in general, or just general careers advice, please do go over there and make the most of this time. For John and Julie, feel free to head over there now as well. If you just click on Expo in the left-hand sidebar and then head to the booth, you should be able to go up on screen. But I think that's everything we had for this part of the event. Thank you everyone for joining and for being so engaged in the session. We really appreciate it, and we look forward to seeing you in the expo.
Fabulous. Makes it more fun for us as well when we also engage. So thank you. So yeah, see you in the expo. All your questions answered, hopefully, as far as the SQE is concerned, as far as we can do. See you there in a mo.